What's up, boss? How you doing?
I don't answer questions.
What's going on, boss?
I don't answer questions.
He doesn't answer questions. Why you seem so upset, boss?
I don't answer questions.
Welcome back to the LackLuster channel. Last August, I released a video featuring Nate and his encounter with Officer Taha of the Westfield, New Jersey Police Department. To bring you up to speed, here is a condensed version of that report. For the update, skip ahead to the time on screen. In August of 2023, a viewer was driving down North Avenue East when an officer of the Westfield Police Department got behind him and initiated a traffic stop.
Can I get your license, registration, insurance, please?
What have I been pulled over for?
Speeding, sir.
What speed was I going?
You're going 48.
48?
48, man.
Damn, that's some horse.
Yeah.
Yeah, I record everything.
The rookie accuses Nate of driving 48 miles per hour in a 35 mile per hour zone. However, the first frame of the officer's dashcam shows the device used to calibrate a vehicle's speed. The first number shown is definitely a 3, but the second number is not clearly visible. Nevertheless, this frame proves that Nate was not locked in at anything over 39 miles per hour. Nate also has a dashcam that records his speeds using GPS. He has supplied me with the footage of his driving prior to the traffic stop, and at no time were his speeds above the legal limit. The rear camera shows the same speeds, but this angle is more damning to the rookie's baseless and unlawful traffic stop. It shows an absence of another vehicle behind Nate for more than a minute, until at the last moment, Officer Taha appears in his cruiser, rapidly closing the vast difference between the vehicles, making it painfully clear that the officer was the only one on scene that violated the law. This is likely because, just a mile earlier, Nate raised a middle finger to the officer as he passed him going the opposite direction, and even at that time, his speeds were well below the posted speed limit.
Are you gonna open this, boss?
What do you mean?
Can you give it to me?
I can. I'm only required to present it to you, and I have presented it.
Okay. All right. So you're just gonna do this, or are you gonna just give it to me?
The law says I just have to present it to you. I have.
Okay, yeah, but
I've presented it.
Can you open?
I can.
So this is what we're gonna do. We're just gonna play games.
For my safety, yes.
Your safety?
My safety.
So you don't want to hand me your license?
I have presented it to you. Legally, that's all I'm required to do.
Okay. All right. Okay. Why you seem so upset, boss?
I don't answer questions.
All right.
The rookie writes down Nate's information. He is again wise to refuse to answer the officer's inquiries. Not only is it his right, but questions like, are we playing games?
We're just gonna play games?
Why do you seem so upset?
Why you seem so upset, boss?
And,
Breathing heavy, man. You alright?
all apply subtle or indirect methods to express hostility, while maintaining plausible deniability and appearing innocent on the surface, when in fact, none of the questions are meant to help Nate or assist them with writing their fraudulent citation. When someone uses provoking questions that seem harmless but are clearly intended to provoke or antagonize, it's a form of passive-aggressive communication. The goal is to create a reaction or frustration in the other person without openly admitting to doing so. Unable to elicit a response from Nate, the officer retreats to his cruiser to learn how to write an incredibly sloppy ticket.
What was his name?
Nathan.
I think we've dealt with this guy.
Officer Picciano finds Nate familiar, but his only citation history is with the agency in the next city over.
Did you have an e-ticket history? An obstruction of windshield.
He likely recalls the first time Nate appeared on this channel, when a Cranford officer pulled Nate over for exercising his First Amendment rights and was issued a citation for a window obstruction.
You drove by and it looked like you needed assistance.
That officer was caught lying in court.
Flipped, like sticking his middle finger up at me for like an extended period of time, as if he was like baiting me to like stop him. I don't know if it's a thing, but it was a video of me on YouTube.
And the citation was thrown out by a judge, but somehow still appears in the officer's database.
An obstruction of windshield.
Those videos will be linked below, but for now, as Officer Taha tries to figure out how to issue a citation, Officer Picciano asks for more of Nate's information.
What's going on tonight, bud?
I don't answer.
What was your name?
What?
What was your name?
You got my ID, didn't you?
No, I don't think you told me. What was his name?
Nathan.
I think we've dealt with this guy.
Well, he didn't take it. He wrote down all my information, right?
Trying to read his handwriting. Nathan?
That'd be correct.
Nathan? Alright.
You said I was lying?
Yeah.
Is the radar gonna lie too?
Funny he should mention it. When Nate reached out to me, I recommended that he request the radar machine's logs and calibration certificates, and one of the documents that rookie officer Taha submitted, directly related to this traffic stop, says that the radar equipment wasn't even used.
What's his issue? Like, I don't understand why he's being so rude.
I don't know, maybe he looks familiar, but...
When we refer to the dashcam footage once again, we can see that before, during, and after that intersection, Nate was traveling nearly 10 miles under the posted speed limit. This intersection is also where Nate flipped off Officer Taha. 20 minutes later, Nate is given his citation.
Yes, sir. I'm going to be issuing you a summons for careless. All the information is on the ticket. It's $88. You can just pay it online. You get, careless. You're driving in a careless manner. I observed you driving 48 to 35, sir, and I perceive that as careless, okay? This is your ticket, sir. You can, this is what I'm giving you, okay? Give me a little bit of break on the speed, and I don't know what's the issue. You know, you seem to be very agitated, but, this is it. Do you have any more questions for me, sir?
Nope, never had any.
All right, so you have a good night, okay? Have a good one. Going off.
Officer Taha claims to have given Nate a break by citing him for careless driving instead of speeding, but when we take a close look at the ticket, the first thing we notice is that the officer marked Nate down as careless driving, likely to endanger person or property, though the dashcam footage proves otherwise. During this stop, Officer Taha verbalized his speed at 48 multiple times, though that is not observed in the dashcam either. But in the notes on the ticket, the officer marked down 49 miles per hour, which would be 14 miles per hour over the posted limit and worth 2 points towards his record. At 50 miles per hour, it would have jumped to 4. On the other hand, careless driving is cited based on purely subjective reasoning rather than observable fact, and is thus easier to argue and lie about in court. It is also worth 2 points and matches the maximum fine of speeding. No break spotted there.
Give me a little bit of break on the speed, and I don't know what's the issue.
But perhaps the break Officer Taha was referring to was marking on Nate's permanent record that he was carelessly driving a commercial vehicle while carrying hazardous materials in his 2006 Honda, all in retaliation for flipping off the officer. Nate appeared in court a total of 5 times to resolve this incident, as prosecutor Howard Egenberg didn't see fit to dismiss the case. A month after the incident, in September, Nate attended his first hearing, where the prosecutor requested discovery. Nate's motion to dismiss was rejected to allow the state more time to provide their discovery to Nate. As it turns out, they had no evidence of any radar or LiDAR, and at that time, Nate submitted the body cam footage to the prosecutor. A month later, in October, the prosecutor requested a second delay, claiming that the clerk never forwarded Nate's discovery to the prosecutor's office. Then, in November, a third delay was requested because the prosecutor, quote, got the email, but the record clerk didn't put Nate's name on it. During that hearing, the judge asked Nate if another extension was okay, and he informed the court of his right to a speedy trial, which is 180 days in New Jersey. Because of that time limit, the trial was set for mid-January. But when January came around, the prosecutor offered Nate a plea deal. Smelling the desperation, Nate told him that he would rather see him try to convince a judge that he was speeding with no radar evidence, and the trial was postponed once again for March. In March, the trial actually took place in person, and Officer Taha even showed up, testifying that the multiple errors on his citations, such as the failure to mark down that he used radar to determine Nate's speed. He claims that he did use the radar, but he just forgot to write it down, but at the same time failed to come with any proof that radar was actually used. The prosecutor focused mostly on the fact that Nate didn't roll down his window or hand over his documents, rather than on the alleged offense. He also tried to enter that the alleged infraction occurred in a 25 mile per hour zone, rather than in a 35 mile per hour zone, but that was easily defeated when Nate moved his dashcam into evidence. This showed that the GPS coordinates and speeds were not the same as what the officer testified to, and confirmed the speed limit or the documented location of the false allegations. The prosecutor complained about the video after the judge viewed it, and tried to suggest that the GPS coordinates were inaccurate, but because he had no timely objections and the judge had already viewed the video, it was considered by the court. And after hearing the state's weak arguments and listening to Taha make a fool of himself, the judge claimed that he couldn't make his decision and scheduled Nate to come back a a 6th time to hear his verdict. And of course, for no good reason, court recordings are still unlawful in some areas. But I have an almost word-for-word transcript of the final hearing, and with a little help from AI, here is what took our most honorable law enforcement, prosecutor, and court 8 months to determine.
This is the matter of Nate. It's for careless driving. Defendant entered in a non-guilty plea, August 9th, 2023, online, and then we had an in-person trial on March the 19th, 2024. In this matter, we had the officer testify regarding a stationary radar regarding the careless driving allegation. In that, the officer testified that he followed the vehicle after observing it, and testified that based on his radar he stopped the vehicle and stated under oath that he was observed to be traveling at 48 miles an hour in a 25-mile-an-hour zone. He requested documents, and he issued a careless driving summons which was within the officer's discretion due to the excessive speed. The radar unit was tested by the officer. The officer indicated he was certified and trained on radar use. The defendant then provided a video and asked for the video to be moved into evidence. There was no timely objection from the prosecutor, so I reviewed the video. When I observed the video had GPS markings with the time, date, and showed mile per hour as well. Based upon the GPS coordinates as well as my own personal observations, the video purported to indicate that the defendant was not traveling in violation of the speed limit. In this case, the state has the burden of proof beyond a reasonable doubt. The defendant is presumed to be innocent of the charge unless each and every element of defense is proven beyond a reasonable doubt. The defendant must be not guilty if there is any reasonable doubt. The burden of proof rests upon the state and never shifts to the defendant. Defendant has no obligation or duty to prove his or her innocence nor to offer any proof relating to innocence. Reasonable doubt is an honest and reasonable uncertainty in the trier of fact's mind. The trier of facts is me in this case, in this court, about the guilt of the defendant after having given full and impartial consideration of all the evidence. It may arise from the evidence itself, or a lack of evidence. Proof beyond reasonable doubt is proof that leaves the trier firmly convinced of the defendant's guilt. It can also provide doubt. In determining whether the state has met its burden, the trier is called upon to determine credibility of the evidence. In this case, we have the witness's testimony, and in determining the credibility of that evidence, the trier of fact may consider many things, such as how good or accurate the evidence is, whether there are any contradictions or changes, whether the evidence has any inconsistency or any discrepancy, the extent to which it's corroborated, contradicted, or discredited by other evidence, the reasonableness of the evidence, and the quality of the evidence. Any motives, prejudice, or biases with respect to reviewing the evidence and the credibility thereof. Common sense should be used in evaluating the evidence. If the evidence does not make sense, then I have the right to reject the evidence. On the other hand, if the evidence seems reasonable and logical, I have the right to accept it and give it credibility. I've had the opportunity to review the evidence. In particular, the officer's testimony. I also looked at the video, and I've had the opportunity to observe its credibility. It's not an easy decision in this case, because we have the officer's testimony, and then we have the video. I'm familiar with these type of videos. They're fairly common in the marketplace, and I have no reason to question the GPS markings. Because the time and the miles per hour are on the bottom of the video, I find the video to be credible. That doesn't mean I find the officer to be not credible. I find that he did seem to do everything right under the circumstances. However, the question here, in the standard of legal review, is whether there's reasonable doubt, and I have to find the defendant guilty, beyond a reasonable doubt, if I find him guilty at all. I find that there is reasonable doubt. A little bit of doubt, but there is doubt because I find the video to be persuasive. So as a result of that, I'm finding the defendant not guilty. That being said, however, there was some discussion in this trial with respect to the defendant making an obscene gesture of contempt to the officer. I think it would be irresponsible for me not to admonish such actions. This allegation of contempt is offensive. I mean, police officers serve a very vital role. They're first offenders, first responders. They're the first to arrive at scenes of emergencies from accidents and crimes. They put their lives on the line. They maintain order and investigate dangerous situations. Their presence provides a sense of security and assurance during times of crisis. They work long hours, unpredictable hours. They face stress and danger, all in the name of keeping our communities safe. So I think we should all take a moment to recognize them and recognize their dedication and express gratitude. And frankly, any offensive gesture of contempt is entirely unacceptable to me. But that's my opinion. I've made my ruling for this matter, and we can move on. Anybody here for this case is free to leave.
Not guilty. No shit. The Westfield Police initially posted a statement about the incident on their Facebook page and reached out to Nate about the incident, but despite the promise that appropriate action would be taken, they never made contact with Nate again or mentioned the encounter publicly after that. Taha appears to still be employed with the town despite the glaring evidence suggesting his betrayal of Nate and the US Constitution. But as always, I'm more curious to know what you think. Is this a moment that should make Americans proud of their government? Or is it blatant and obvious corruption that should have included Taha's name on the Brady list? Let me know in the comments down below. It's possible that this story is not over, and if Nate pursues civil action, I will be sure to let you know.